My name is Gene Fraser, and I'm leader of CBM Lawyers' estate litigation team. Wills enable us to declare how we would like our assets distributed when we die. Usually a will is respected and upheld by the courts, but there are exceptions. A large portion of my practice is helping individuals who feel they might have been unfairly treated in a will. The spouse or the biological or adopted children of the deceased who feel they have been unfairly treated in a will can petition the court to vary the will. Our ability to do this came into effect around the beginning of the 20th century when, usually men, might have tried to leave all of their money to a girlfriend, pet, or charity instead of properly taking care of their spouse and dependents. The purpose of the legislation was to protect the rightful inheritors, but also to ensure that the government did not need to support as many destitute dependents. The law is based on the belief that a will maker has an obligation to provide something for those they have been legally responsible for and leave behind. The law ensures that children and spouses of the will maker are properly cared for by the estate. Who would typically challenge a will? In a family with multiple children, if all or the majority of the assets are left to one child, the others could go to court to challenge the fairness of this distribution. If a child or spouse finds they have been disinherited and a good reason cannot be provided, then they have grounds to request a variation of the will. If children from a first marriage find that their inheritance is a pittance compared to that of a new wife, they can request a variation. The age or dependency of the child may not be relevant. A 60-year-old son can request a variation of the will of his 85-year-old deceased father. Even a valid will can be challenged. The determining factor is whether or not the will is fair, and fairness can be challenged on both legal and moral grounds. How often are wills challenged? In most other provinces in Canada, a will cannot be varied, but here in BC, this is one of the most frequent estate issues in BC courts today. Contrary to what you might think, in most circumstances, you cannot fail to provide for your biological or adopted children or spouse under your will. This doesn't mean distribution has to be absolutely equal. There could be legitimate reasons to leave more to one beneficiary than another. For example, if one child has looked after the deceased for a significant period of time, or has been more involved in the family business, or made some other contribution above and beyond that of the other siblings, there may be valid cause for an unequal distribution of wealth. The circumstances of the beneficiaries might also be taken into account. If one of your children is a millionaire and the other is struggling, it may make sense to provide a different inheritance to each. Or a child with disabilities may legitimately be given a higher percentage of an estate. However, in the absence of such obvious reasons for a difference in inheritance, the courts will look for fairness and equality. On the other hand, there may be good reasons to disinherit a child or spouse. I recall one case where a child had attempted to have his parents murdered. No court would demand that this subsequently disinherited child was suddenly entitled to his parents' wealth. If you feel strongly that you have good cause for disinheriting someone, there are ways to plan for that, but it's best to see a lawyer to do so. In some circumstances, it may also make sense to plan your estate so that fewer assets are distributed through probate. For more information on this, check out our video on house inheritance issues. If you need to write or update your will, our Wills and Estates group can help. If you feel you've been unfairly treated in a will, our estate litigation group may be able to assist you in varying a will. Give us a call and let us help you whatever you need.